Elizabeth started as an examiner within the National Labor Relations Board and worked her way up. Elizabeth has served the entirety of her tenure with the National Labor Relations Board in Detroit and the greater Detroit area. After Ms. Kerwin will be Benjamin King, a Michigan labor attorney. Mr. King is a partner at McKnight, Canzano, Smith, Radtke, and Brault, a leading Michigan labor and employment law firm. Ben received his JD from Wayne State University and represents union workers and benefit plans in litigation, arbitrations, and NLRB proceedings. Ben represents clients in state regulatory proceedings from the ERC, PSC, and Teacher Tenure Commission. Ben is also a member of the Industrial Workers of the World. After that will be two union organizers. One, Brian Shepard, who is the UAW organizing director. Originally from Iowa, Brian is an active member of the Democratic Socialist Party and served as the campaign manager for Democrat and unionist Kathy Gleason. He went on to lead organizing efforts for SEIU in Texas, as well as consult several more unions and related organizations. Brian is also a proud U.S. Navy veteran and jiu-jitsu black belt. And finally, Jordan Easley. Jordan is a dedicated advocate for workers' rights and social justice. He's a proud graduate of Hampton University and channeled his passion and energy into the labor movement for over 15 years. He now serves as the organizing director for the International Chemical Workers Union. Throughout his career, he has been actively involved in multiple organizations, making significant contributions to the advancement of workers' rights. So now on to the panel. We'll start with Ms. Kerwin. Those who have questions, please type them in the chat, and the Senate Director, Michelle Fecto, will read them to the panelists during the Q&A portions. Take it away, Ms. Kerwin.
All right. Well, thank you so much, Nolan, and to Michelle for organizing this event. And it's a pleasure to be invited to speak. I'm really happy to be here. I am going to share a couple visuals if I am successful in my attempts to do that. Is everybody seeing a PowerPoint right now? I hope. Yes. Okay, great. As Nolan said, my name is Elizabeth Kerwin. I'm the Regional Director of Region 7 of the National Labor Relations Board. So we cover almost the entirety of the state of Michigan. I have a few counties up in the western edge of the Upper Peninsula that belong to my friend Jenny in Region 18, but otherwise we've got the rest. If my slides will move. There we go. All right. So I want to talk a little bit first about numbers related to organizing. We're here to talk about organizing today. So I have some visuals. This is a 5-year look back at how many representation cases the agency itself has handled in the last 5 years. And as you can see, and I don't think it's a surprise to any of you that the numbers have gone higher the last few years. 2022 and 2023 were really close, 1,522 RC petitions and 1,525 RC petitions. There's been a huge uptick in organizing. So I don't have to tell you that, you guys know that. This is a look back, a 5-year look back at Region 7's representation cases in the last 5 years. We almost hit 100, we missed it by 1. I think we will, continue to see huge volumes. People always are asking me, well, like what, this is all Starbucks, right? Like that's what it is. No, it's not. It's kind of everywhere all at once. It's not any one particular industry or company. In 2022, 16 of those 74 were Starbucks, but in 2023, only 4 of the 99 were Starbucks. So you guys know this as well. The interest is everywhere. So we're seeing petitions in all kinds of industries, some that we haven't seen in decades. Financial services, for example. We certified a credit union unit earlier this year that I believe was the first financial services unit in decades. So that's an interesting one. Region 7 also handled the first organized Chipotle in the country. We certified that one, which is out of East Lansing. That one was last year as well. So a lot of history making organizing going on. And that's not going to change, I don't think, in the near future. Another question that people are always interested in when we're talking about organizing is, well, how fast are we getting to an election? And before you guys yell at me for how these numbers look, I have an explanation for that. It's a very reasonable one. So 2019, it was taking about 24 days from the date you filed your petition until the date we got to an election. And that's the median days, but that's, you know, a good number to kind of reference. That's pretty much lightning speed for elections. In the decades before that, it was always in the 40s, but there was a rule change in 2015 that really sped up the election process. And the rules changed again in the middle of 2020 that added more time. So I swear it's not our fault. It's just the rules. The rules added a lot more time. And so that's why you see 2021, 2022, and 2023, it took longer. It took, you know, last year, 40 days. If you're an organizer, there's some good news coming your way because the rules are changing back to what they were pre-2020. That becomes effective December 26th. So if I were guessing, I would guess that our median number of days moving forward is going to look a lot more like it did in 2019. We're probably going to hit somewhere in the 20s moving forward. You know, that's what you can expect post December 26th. Leading up to that, things are still taking about, you know, 40, 42, 43 days to get to an election. I'm not going to spend a ton of time on this, but if it is something that you have concerns or questions about, we can talk about that a little bit more later or in the question and answer. Not sure if everybody's really fully aware of what the staffing and resource issue is at the NLRB. I used to use the word crisis, and then someone told me crisis is temporary, and this appears to be like not so temporary. So I'm trying to find a new word besides crisis. But you know, when I was the assistant regional director and I was kind of in charge of keeping all the statistics about our open cases, we were generally carrying between 130 and 200 open cases at a time. And we had about double the staff we have right now. We're carrying 700 open cases right now with half the staff we used to have, even just 3 years ago. And so what that means is, you know, if you average it out, it's about 47 cases per agent, which is not realistic to ask them to do when they're also handling representation case petitions and trials and elections and all the other things that are demands on their time. Just as an example, the most cases I ever had as an agent was 13, and that was so challenging for me to juggle at the time. So 47 is sort of an impossible ask. Obviously, that results in, you know, some delays with cases, some significant delays at times. And we are, you know, representation cases are always a priority. We never set those aside. They are always being processed as quickly as we possibly can. But, you know, out of organizing campaigns also arise unfair labor practices oftentimes. And we also are trying to prioritize any unfair labor practice case that relates to an organizing campaign. But, you know, if we miss that's happening and we've set it aside or sent you a letter saying your case is going to be delayed, and you say, well, hold on a minute, it relates to an organizing campaign, you just got to call us and tell us that was not intentional. So I'm going to talk really about what you're most interested in right now, which is some, you know, what's going on at the board as it pertains to organizing activity, and some significant board decisions and other things that are going on that would impact union organizing. This is a picture of the current board. We have 4 members. We should have 5. There's a vacant position. It's been vacant for over a year. It's a Republican seat that's vacant. And so we have 3 Democratic members and 1 Republican member right now. I've been hearing some rumors in the last week about the potentiality of filling that vacant seat. I haven't heard a name and I haven't heard a timeline, but there is some thought that might be on the horizon. So stay tuned for that. So the first decision I'm going to talk about, before I talk about it, I want you to know how other people are talking about it in the press and how it's being talked about sort of in the public eye. I Googled the name of the case and I just pulled some phrases off the internet to share with you about what people are saying about this decision. Some people call it a game changer, a radical decision, unions score big win, drastic departure of established legal precedent, good news for workers, union busting just got a lot harder, dramatic, wipes out decades of precedent. So, of course, depending on kind of what side you do your work on, if you are an employer side, a union side, maybe you're an academic, whatever, might change how you describe this decision. But clearly, you can see kind of no matter which side you're describing it from, it's a significant decision with really, really significant impact. So what I'm talking about is Cemex Construction Materials, 372 NLRB number 130. It's a decision from August 25th. That's supposed to be a picture of cement. I don't know. I usually try to put like a flashy something related to the name of the employer. And all I could come up with was concrete. So in Cemex, the board announced a new framework for determining when employers are required to bargain with unions without a representation election. So under this new framework, when a union requests recognition on the basis that a majority of employees have designated the union as their representative, an employer must either recognize and bargain with the union or promptly file an RM petition seeking an election. However, this is a big piece. If an employer who seeks an election commits any unfair labor practice that would require setting aside the election, the petition will be dismissed. And rather than rerunning the election, the board will order the employer to recognize and bargain with the union. So I think, some talk about this is the idea of, disincentivizing breaking the law to avoid a union. Some employers may have an approach of, I'm going to violate every which way. I don't care, because I'll just keep doing that. And eventually, they'll go away. So I think I've heard some talk about, the idea of that campaign is no longer a viable option because you're going to get a bargaining order if you do that. So there's this handy little chart that the NLRB released, and this is a really helpful tool because it's a little bit hard to wrap your head around this. The number one thing that you've got to do if you're organizing a unit is ask for voluntary recognition. If you don't do that, Cemex is never ever invoked. You never get a shot at a Cemex bargaining order. So some union organizers, I think, do a voluntary recognition as a matter of practice. Some do not. There is some question about, well, what about if I check that box on my petition when I file it with the NLRB and I say petition serves as demand? Is that enough? The general counsel, who has issued a memo with some sort of case handling guidance about Cemex, she would say, yeah, that's enough. I think that's enough. We don't know necessarily if the board thinks it's enough. So there are a lot of questions surrounding Cemex, but it all starts with that request for voluntary recognition initially. And then you can just kind of follow the flow chart. If the employer chooses not to recognize the union in response to the voluntary recognition, there's a couple different options. We can go the RC path, we can go the RM path. But if there are unfair labor practices committed, they might end up with a bargaining order at the end of the whole thing. What we have seen is a whole bunch of RCs and RMs coming in. The employer is filing the RM, the union's filing the RC, and we're kind of just letting them live together as one consolidated case. But there's been a huge uptick in those. So the general counsel just released a really, really helpful video. I'm going to play that video for you. It's 2 minutes, so don't worry. We're not going to be here for a full feature. I have to unshare and then reshare. So just give me 1 second to get my technology to cooperate. New share. Okay. All right. Is everyone seeing something new and interesting?
The NLRB recently issued an important decision in a case called CEMEX that changed the framework for union organizing and collective bargaining in the United States. In CEMEX, the NLRB explained that employees' fundamental rights under federal labor law to organize and collectively bargain were not being adequately safeguarded. So they announced a new framework consistent with Supreme Court case law. Under the new framework, you have a right to request that your employer recognize your union if a majority of you and your coworkers support union representation in a work group appropriate under labor law. You or your union can make this request through a petition for an election with the NLRB or directly to your employer. If a request is made, your employer must recognize the union and bargain, unless your employer challenges the validity of the request, either through your union's petition or by filing its own petition, generally within 2 weeks. If a petition is filed and your employer commits an unfair labor practice that would require rerunning the election, the NLRB will dismiss the petition and order your employer to recognize your union and bargain in good faith. So make sure you know and enforce your labor rights. If you believe your employer is violating your rights, you can call your NLRB regional office at 844-762-6572 and get assistance filing an unfair labor practice charge. A Spanish language option is available when you call, and we can provide language interpretation in other languages upon request. You can also visit our website at nlrb.gov to get more information or e-file a charge in English or Spanish.
Okay, that was exciting stuff. All right, let me go back to my slideshow. All right, so a lot of you might be asking, like, where do I find this video? How do I get this video? I want to tell everyone I know about this video. It is available at the NLRB GC Twitter page, X page, whatever we call it now, which is on X, Twitter. NLRB GC is where you can find that. I was not able to download it, which is what I really wanted to do, so I could circulate it to others. But it is there. That's where you can find it. Of course, it's going to generate a lot more questions. Hold on, let me get back to this. All right, so there is more CEMEX guidance in this document called GC 2401, which answers probably a lot of the questions that are swirling around in your mind right now about CEMEX. That's all general counsel guidance that is meant to tell the public and the regions, here's how I want you to interpret the board's decision in CEMEX. So take a look at that document. It's available on our website at nlrb.gov under guidance. Really, really helpful information in there. And I'm just going to touch on a couple other things, and then we can open it up to questions. Another significant board decision that pertains to union organizing is, and I don't want to talk in super technical terms, but we used to have a standard called specialty healthcare, where you could organize, generally speaking, in kind of a smaller unit. And then that law got overturned by a case called PCC Structurals, which made it harder to organize in littler units. And it had to be kind of a little bit bigger unit, which as organizers, you know, sometimes it can be challenging. It has now, gone back to the specialty healthcare standard where you can go back to smaller units unless the employer can show there's an overwhelming community of interest with the other people it's arguing have to be included. So that can be a really important thing that you can miss. When you're organizing a group, you've got to make sure your appropriate unit is going to stand up. So now that's a little bit easier with the change in case law. Just a couple other things I want to call your attention to that do have impact on organizing. One of them is the GC's memo 2204. Where now this is not board law yet, but she's trying to argue to the board that captive audience meetings are unlawful. So obviously that's something you're running into a lot in organizing campaigns. You bring it to the region as an unfair labor practice. If there's a violation of something under existing case law, you will very likely find that we're also going to prosecute the idea of a captive audience meeting being unlawful. Again, I talked about the election rule changes coming on 12/26. It's basically if you practiced under the 2014 rules, we're going back to those. So it's going to be a lot faster. A couple of these other things, you know, injunctions relating to organizing campaigns. Any of you interested in organizing student athletes? The general counsel is signaling that she thinks they have rights as employees. And then a lot of focus on immigrant workers. So if you are, you know, working on an organizing campaign with immigrant workers, the NLRB has done a lot to try to safeguard their access to the NLRB and ensure their voting rights. And in some situations, that might be the only election that an immigrant will ever vote in because they have voting rights under the NLRB, documented or not. And we're also doing some assistance with helping to keep immigrants in this country, regardless of their status, when they are assisting in unfair labor practice cases and things of that nature. So for those of you who may be involved in organizing campaigns involving immigrant workers, those are things that are really interesting to pay attention to. That's all I have. It's kind of a lot, but I wanted to just make sure I left a little bit of time for questions. And back to this list, any of these you can kind of get lost in, you know, reading those and thinking about what those concepts mean for your organizing campaigns. So I'm happy to talk about, you know, a little more deeply about any of those or SEMEX or whatever questions you might have. So I will turn it over to the question and answer facilitator.
Okay,
Thanks, everybody.
hi. Hi, everyone. I'm not seeing any questions in the chat. I would open it up. Is there anyone who has a question who would like to just raise their hand or speak and ask a question?
Actually, Michelle, Roland Zulo had posted a question in the chat.
Oh, I missed it.
CMEX looks even stronger than Giselle, correct? Or just sort of your take on that?
Yeah, that's a great question. A lot of people are trying to understand what's the difference between SEMEX and it's called a GISL bargaining order. And you know, is SEMEX a GISL? Is a GISL SEMEX? Like, what's the difference? I think it looks to us like the framework to getting to a SEMEX order is an easier path than a GISL order. And a GISL orders are awfully hard to come by. In Region 7, we litigated one many years ago in a really, really tough organizing campaign. And we won a GISL order in front of the judge, but it was like years later, you know, it was, I forget, 3, 4, 5 years after the initial organizing campaign. And that sort of, you know, kind of doesn't have the same impact as we can seek a SEMEX real quickly and hopefully rectify that situation. One thing that I will say is that, you know, if you read anything in the press about SEMEX, there's a lot of talk about whether SEMEX can survive a challenge in the circuit courts or perhaps the Supreme Court. That's where it is headed next. It's board law now, so it's what we are applying. But that doesn't mean that it's going to necessarily survive a challenge at the next level. And so GISL is the law of the land. But SEMEX, you know, may not survive. We'll see. You know, we're certainly prosecuting cases as if SEMEX will survive. But I think there's some concern from some folks about what if I get a SEMEX bargaining order and, you know, the Supreme Court undoes it. So it's just something to be aware of. But to the extent you're asking, like, this seems like a little bit easier than a GISL to obtain, it sure looks that way to us as well. I would agree with that.
Okay, we have a couple other questions, but could you just give a brief explanation of GISL for those who might not know in the group?
Sure, yeah. So a GISL bargaining order is typically sought in a situation where there's been an organizing campaign, there's been an election, the union loses the election, and what the NLRB argues is that the employer's conduct and unfair labor practices are so pervasive that we couldn't possibly ever have a free and fair election. And so, there are remedies to unfair labor practices that are meant to reset the table and then proceed to an election after you've reset the table and remedied everything so you can have a free and fair election. So Gissel is, the burden is really on us to show it would never be possible to have a free and fair election. So the standard is really, really difficult to meet because, there's all kinds of remedies. There's notice postings, there's reinstatement and back pay. And the idea is once you've effectuated all those remedies, why can't we have a free and fair election? So that's the idea of Gissel. You can see kind of why it's complicated. What they've done with CEMEX is they've said any unfair labor practice that you have committed at all that would result in us ordering a new election, we're not going to do a new election. We're just going to issue a bargaining order. We're going to skip all of that and go straight to the bargaining order. So it's a much lower bar. We don't have to prove that a free and fair election would never be possible. We really just have to prove that an unfair labor practice occurred that would have resulted in a new election and go straight to the bargaining order. So I hope that explains it a little bit. Yeah.
That's great. And we do have some questions. Mark asked, why are NLRB seats partisan?
So that's written into the statute itself as far as how the vacancies are filled. They are president appointed and Senate confirmed. And so typically the presidential party that's in power appoints 3 of his or her party and 2 of the oppositional party. There used to, I think in the past, to be more inclination, and I mean like the 40s and 50s, more inclination to appoint maybe academics. But it has, really been more practitioners being appointed. So people who came up through union side practice or employer side practice who kind of know the NLRB. As far as, the partisanship of it, I mean, that's really up to the president who's appointing them and the Senate who's confirming them. The general counsel is also presidential appointed and Senate confirmed. And so, of course, whatever party is in office, they have their agenda they're looking to get through as it relates to labor law. And they appoint, I presume, sort of based on that agenda. But as far as all the inner workings of that, it's written right into the statute from going back to 1935, I think.
Okay, thank you. We have a couple more questions. We've got, let's see, Cliff says, any information on how this ruling, CEMEX, I guess, affects non-disparagement clauses in settlements? Like, does it effectively negate them? And then there's a link.
Yeah, so I see the link. I'm not sure what this case is about. So, I know what you mean. Okay, yes. This relates to the McLaren-McComb decision, which is actually a case that came out of Region 7. So I know it very well. There is a general counsel memo giving guidance about what we think the board's decision in McLaren-McComb means as well. Again, it's the general counsel's interpretation of board law, but she does make it a point to say in this memo that, this is not the end of severance agreements. We're not getting rid of severance agreements, but you can't have certain clauses in them like non-disparagement. You can't buy silence essentially with a severance agreement. So taking a look at the general counsel's guidance on that, which is again available on our website under general counsel memos, you can really see how she interprets it. And she also signals that there are other clauses that she would find unlawful in these severance agreements above and beyond what McLaren-McComb found, which was a non-disparagement, like you can't talk bad about your former employer, and a confidentiality clause. So we see these all the time and we issue complaint on them all the time. They are pervasive out there for sure.
Thank you.
We've got time for a couple more questions. Michelle, if you can maybe read those final two, and then we're going to move on to Ben King.
Okay, thank you. Well, this is a quick one. Does the 47 cases per agent figure include our cases?
That's an insider there who knows how we run our numbers. Hi, Neil. That does not include our cases, and that does not include any litigation figures. And so for our field examiners right now are carrying anywhere from 2 to 5 R cases at a time. So, 47 C cases plus maybe up to 5, you're in the 50s of cases you're handling, which, as you can imagine, is a little bit crazy making for them. But good question. Thanks for asking.
Okay. One more. Now that there is precedent coming back that forces employers to speed up election times, is there any work being done to create precedent to force employers to sit down and bargain with unions in a more timely manner?
That's a really good question. And I think that's a really tough issue for unions that we see, that there's some delay occasionally. I think number one is the union has to be very aggressive about demanding bargaining, offering dates, being as flexible as you possibly can to make the best case for yourself if the employer is not coming to the table in a timely fashion. And I know Neil Pettit is here. I've just seen from working with him before, tricks up his sleeve. I mean, he kind of just papers the employer with he's sending letters every night. Like, hey, when are we meeting? Let's go to the table. I'm available from 6 a.m. to 6 a.m., 24 hours around the clock. Let's do it. The more aggressive the union is, the easier time we can show if you come to us and argue, look, the employer is not coming to the table. It makes it a little bit easier for us to step in and say that they're bargaining or acting in bad faith. But unfortunately, it is the way the case law is right now. It is very difficult from your perspective to get to a surface bargaining or a bad faith bargaining very quickly, because those require such an overview of the totality of the circumstances that sometimes you'll come and we'll say, I don't know, they met a couple times, it looks like they're doing what they can, or they had this excuse or that excuse. And sometimes it can just take a longer look before we can say, yeah, there's enough here to say they don't want to come to the table. Keep pushing it and do what you can and come to us when you think you've got enough, and we'll tell you if you do or don't. Yeah.
That sounds great. And there's 2 other questions, but I would ask Elizabeth if you could respond to everyone, and could you answer those questions in the chat?
Sure, absolutely.
Okay,
Yes.
so we won't cut into Ben's time.
Absolutely. Thanks,
you.
everybody.
Yeah, thank you. That was wonderful. Appreciate that. Sorry, I'm handing it back to you, Nolan.
Yeah, thank you. That was great, and those are all great questions. Now we have Ben King.
All right, just a second. Okay, hang on, I got a lot of stuff open. Ah. All right, I'm Ben King. I am a labor attorney at the law firm McKnight, Canzano, Smith, Radtke, and Brault. I've been practicing union side labor law exclusively for 6 years. I handle a lot of representation cases, bargaining, just the kind of gamut of traditional labor law. So what I wanted to do here today is to just give an overview of kind of traditional representation cases and give my insight on where I think there are, frequent pitfalls that I see organizers make or lawyers make, and then also tips and tricks that I find helpful in expediting the process and being successful in organizing. I will say, I'm not an organizer, and I'm an attorney, and sometimes my advice to my clients who are organizers is, sometimes contrary to the goal of, winning hearts and minds. I'm a lawyer. I always, try and advise my client to proceed with an abundance of caution. And sometimes that can be contrary to winning an election. So take what I say when you're organizing with a grain of salt, but I'm hoping that this will be helpful. So as a union lawyer, I view representation cases as, there are three potential opportunities for election, for victories or defeat. There's your pre-election decisions, which happen before you have an election. So whether there's a community of interest, whether the bargaining unit's appropriate, then obviously the election itself. And then there's, this idea of how do you preserve a victory or how do you overturn a loss after there's been an election? There are sort of two themes I want to have you all take away from this. One is that, time is always the enemy. The longer this process gets dragged out, the more difficult it is to win an election and the less potent, unionism can be, if things drag out. And then the last thing that I think is really important when you're handling a representation case is to know the work that's being organized. And most organizers are really good about this, but it's hard. You have one job and you're organizing work that's, in a completely different industry or field, but oftentimes oftentimes that can be really compromising. If you don't understand the work, you don't understand what's being done. So at the outset, before you can initiate a case of the NLRB, there are two things you need. You need a showing of interest and you need to file a representation petition. So a showing of interest is what's traditionally called a card drive. It's collecting cards. This is a card from when I organized before I was a union labor lawyer. You need to have 30% minimum. I think most organizers generally recommend having 2/3 of the potential bargaining unit sign authorization cards. Liz talked a little bit about Gazelle, and there is this, I rarely see this happen, but there are two sort of magic words that you need to have on an authorization card to get a Gazelle bargaining order, and that is authorize and bargain. I rarely see it happen, but every now and then I'll have a client who is trying to form, an independent union, and they'll make their own authorization cards, and the cards will just speak, exclusively to having an election. And they might get the election, and the employer might commit unfair labor practices that could potentially, end up in a Gazelle bargaining order. But without that authorize and bargain language, you're not going to get that. Again, very rare, but there's lots of good templates for authorization cards out there. Just make sure if you're making your own that they have the authorize and bargain language on there. So once you file the petition, that's when you're going to have your sort of initial dealings with the agency. As soon as I find out who the board agent is that I'm going to be working with on this case, as soon as I get a docketing letter, I pick up the phone and I call that board agent and I introduce myself. I try to give a brief overview of, the work that's being organized. And then, I just say, I'm here. This is my direct line. Give me a call. Let's get this thing moving. Anything you need, let's talk. As the person dealing with the board, you're the conduit of information. So they're going to be asking you a lot of questions about the work, about the location that's being organized, the history. So you have to have all that information. And I find you want to get that information to the board first before the employer does, because inevitably the employer is going to be telling a potentially different story than you. And then my last point, when dealing with the board is, be an advocate, not a bully. Because again, when they're, they have timelines, they have timeframes they're trying to meet, and so do you. And if you've alienated a board agent and they don't want to talk to you on the phone, then they're not answering your calls, and you're doing, the disservice to the union, the organizing drive. So just, be an advocate. Nobody likes a bully. And then the board agent's going to work very hard to negotiate an election agreement. And these are sort of three key points that I like to, make sure and you're aware of when you're negotiating an election agreement is you want to know the work, You need to know the people, the places, and the culture. So this really boils down to where the election's going to happen, what time, and sort of like the almost like the boring details of the election, but they do matter. And I'll give one sort of anecdote that I've heard to sort of emphasize how important this is. It was a public sector organizing drive of a water board in a small town in rural northern Michigan, and they had an election agreement, and on its face the election agreement looked absolutely fine, but the location was building number 2, and the date of the election was November 15th. So again, on its face, that election agreement looked good, but a call to the organizer on the ground would have revealed that building number 2 was the wastewater treatment plant that smelled awful, and November 15th was the opening day of deer season. So it's like it's important to know those things, because if they had scheduled it for that building location and that day and time, there's a real possibility that people are off, they're not going to show up, and November 15th in Metro Detroit might mean less than November 15th does in Bay City or Saginaw or somewhere further north. An important piece in the pre-election piece is appropriate bargaining units, and this is where we get to that first potential for victory and defeat. And this is again why it's important to know the work that's being organized. And this is where, in an RC case or in an RM case, the employer is going to raise objections and say the unit that you organized is inappropriate for some reason, and it's because it doesn't fit within this community of interest. And a community of interest is all the factors that the board reviews to determine if a unit is appropriate. So it's compensation, hours of work, benefits, supervision, qualifications, interchange, integration. The way I like to think about it when I explain this to clients is if you have multiple classifications and you put each of them in a circle and you create a Venn diagram, the amount of overlap that those positions have in these factors is sort of an easy way to think about community of interest. And then, just as an FYI, there are some presumptively appropriate units. So there's single facility, production maintenance, well-to-well units, and certain healthcare. And there's a lot more presumptively appropriate units, but those are just kind of the common ones that you'll run across. So if you haven't been able to negotiate an election agreement and there's an issue of whether the bargaining unit's appropriate, you're going to go to a hearing before the NLRB. Oh, and then, sorry, before I jump into that, and Liz touched on this a little bit, the standards for, and I'm not going to go into the sort of minutia here, but the standards for what an appropriate bargaining unit is change every time, there's a Republican board or a Democratic board. And under conservative boards, the standard's higher and it's harder to organize smaller groups. And then when it's a Democratic board, it shifts and it's easier to organize the smaller groups. So these are the current case is American Steel, which is a reaffirmation of specialty healthcare, and it overturned PC Structural and Boeing. And that changes, depending on who's the president and who is in the board, that changes every, 4 to 8 years. So if you haven't been able to agree on, the appropriateness in the unit, you're going to have a hearing before the region, and the hearing's usually conducted by a board agent or a board attorney, and you have to present a case. And again, you're just going through those community of interest factors. How similar are the jobs? How dissimilar are the jobs? But all of that is going to hang on who you're presenting as witnesses. So
I just made this motherfucker nervous. That's the guy that owes me $250. He's an organizing director for UFC.
Oh. So it's important to find your witnesses, and the best witness is somebody who really knows the work, someone who's been at the job site for a long time, someone who understands all the classifications, someone who knows the other employees. So the first sort of step is finding your witness. And then the second thing that's important to do. And I think people often kind of overlook this, is you have to secure your witness. And a lot of times folks are going to be nervous about testifying. They're going to be uncomfortable. They're going to be afraid of retaliation. So one of the first things I do when I file in our case is I also request subpoenas from the board so that I can secure that witness through a subpoena. And that just adds an extra layer of protection for them. And it just, it mitigates the headache of not having, you know, your best witness testify to the work that's being done. And then prepare your witness. I mean, our case hearings can go on for days, they can go on for weeks, but at the end of the day, your witness is going to know more about the work than anybody else. They're going to be the best qualified people to testify about the work that's being done. And I like to just sort of, when I'm working with the witness on a representation case and talking about their testimony, I like to just really boil it down and just simplify it. You know, what do you do when you get to work? What do you do? What is your job? What do you do when you get there? Where do you do it? Who do you do it with? Who are your coworkers? Who's your supervisor? What other departments do you interface with? When do you do it? What time do you show up for work? What time do you leave? Do other people have the same schedule? And then how do you do it? Did you have special skills, training? Did you go to college? And then the last question is, you know, what do you get for it? What benefits do you have? What other benefits do people get? So I just, you know, our cases and hearings get really complicated, but at the end of the day, it's really like, what do you do? Who do you do it with? And where do you do it? And what do you get for it? So after you have a hearing, the region will issue either a dismissal of the petition if they find that the bargaining unit's not appropriate, or they'll issue a decision and direction of election. And then you get into the election. And there are sort of three kind of things I want to hit here. The first is an eligibility list. So before the election, the employer is required to submit an eligibility list to the union and the board. So again, it's important to have that close connection with your people on the ground, looking at the list, who should be on there that's not there, and then who is on there that shouldn't be on there. And then during the election, you'll also get to choose an observer. And you also, again, you want to have someone on the ground who knows everybody, knows who should be there, knows who shouldn't be there. But you also want to have somebody who is confident and can make challenges to voters, but then is also non-confrontational and isn't going to create elections or issues in the polling place that are going to later lead to objections when you've potentially won an election and then are now going to have to do a rerun because there were issues at the polling place. And then my last advice, and this is sometimes contrary to what my clients, my organizers want, is I say, like, treat yourself. You've done all this work, you put in this time to organize people. Now it's time to just, on the day of the election, I typically tell my organizers, my clients that I'm working with, just, go get an ice cream cone, go get a piece of pie, get away from the polling location. Because inevitably, my clients that, will wait in the parking lot across the street or, put on a little rally down the street, the employer is going to file objections. And again, this is sometimes contrary to what my clients, want. Getting votes, sometimes you got to do that stuff, but, inevitably the employers are going to file objections and it just drags it out, whether or not those objections are valid or not. So during the election, there, are certain things you can and can't do. And these are, things that are generally considered election misconduct and grounds for objections to an election. So just some basic do nots: don't keep lists or appear to keep lists of who is voting. Don't film or photograph voters, and don't campaign or electioneer at polls. One issue that I've seen come up a lot in the last few years, just with the kind of advent of, everybody recording everything all the time, is, if there's a dispute or argument at a polling place, everyone is like very quick to reach for their cell phone and start recording. And that can be a a basis for an objection and a basis to overturn an election, depending on who's doing the recording. So I just, really caution my clients to be careful about, recording or appearing to surveil people as they're voting. But on the flip side, you do want to monitor the employer for doing that kind of conduct, because that can be grounds for overturning an election if you lost, or potentially getting a bargaining order. And then SIMEX at the end here, this is, I think, uncharted territories. This is sort of a reaffirmation of Joyce Silk, which has not been the law since 1969. So this is very new. I think people have a lot of questions. I know I have a lot of questions. I've handled our cases since SIMEX has been the law, but I haven't, utilized that. So the two sort of key takeaways that I get and that I'm advising my clients is to obviously ask for voluntary recognition, and then file unfair labor practices. If you think there's something that's unlawful that impacted the election, file those charges. I mean, there's no real cost to filing them. And if you're going to get a bargaining order, it's well worth it. And it just, it's uncharted territory. And I think it's very exciting times, but there's a lot of uncertainty, and it's, proceed with some caution. So thanks for listening to me. And a couple of resources I, wanted to point out. There's an outstanding, almost definitive manual that the board publishes, outline of law and procedure and representation cases, that is just like, it has almost all of the answers. If you have any questions about bargaining unit appropriateness, election conduct, I mean, it's got it all. And then the last point I want to make is, all this case law is great. All of, this precedent changing is amazing. Having an aggressive general counsel is great. But if we don't have a functioning board that can process cases, then we're in a lot of trouble. And it's, it's the next election's coming up, and the board law could change, and all that work that's been done, or all that work that's trying to get done, is, all for naught if we have a board that can't handle the cases or can't process them in a time that's, meaningful to organizing campaigns. So I always, strongly encourage people to write your legislators to fund the NLRB or increase funding. And that's it. So any questions, I'm happy to try and answer them.
Again, I don't see any questions in the chat so far for you, Ben. So I would suggest, is there any questions from people in the room? If you want to raise your hand or just speak.
You have one in the chat. There is a question about how neutrality agreements differ from the recent SIMEX ruling. I don't know, Ben, if you have any thoughts on that.
I honestly haven't really thought about it. No, I don't have the good answer for that. I haven't thought about it.
Mm-hmm.
Elizabeth, if you want to jump in, I see you
Yeah,
unmuting
I was just gonna
yourself.
jump in and say that they're, I think, two completely different animals. A neutrality agreement is typically the employers agreeing, like, all right, you can do your campaign, whatever. I won't say anything bad about you guys, right? But they're not really committing to bargaining with you or anything like that. Where the SIMEX is, they're not going to have a say in the matter. We're going to order a bargaining relationship under certain circumstances. So I think they just really live in two different worlds, neutrality agreements and SIMEX.
Okay. We have another question. How difficult is it to get a supervisor in the same union as the same union? Employer has created union work stating they cannot be in the union because one evaluates those currently in the union. So I guess the question is about how has supervisors, how do you handle those kind of cases in determining who's a supervisor and not?
That's a good question. So the act specifically prohibits supervisors from being in a union And that's a common issue that comes up where you file a petition and some of the workers that you're trying to represent, the employer is now claiming that there's supervisors. Again, I mean, the sort of standard is, does that supervisor have the ability to hire, fire? Do they control work? And it's going to ultimately end up being a very fact-specific analysis. And depending on what the facts are, you know, the supervisor could be a supervisor, they might not be a supervisor, you know, that the outline of law and representation is going to be your #1 guide for applying your facts to the law. I mean, it's got all the answers. I mean, it's just a checklist. Does that supervisor, do they have the ability to make hiring decisions, firing decisions? Evaluations are relevant, but you know, it's always a fact-specific analysis, and I can't, you know, sell the outline of law and representation enough. It's got the answers.
Thank you. Let's see. Would you recommend one over the other? Oh, or it depends on the circumstances. So I guess this is the traditional bargaining as opposed to the new CMAX.
That's honestly a great question, and something that I've thought about a lot and even struggled with. I guess, you know, time will tell, but sort of, I mean, I'll just be honest. What I'm recommending to my clients is to make the demand for bargain, and then, you know, maybe you want to wait a little bit longer than you normally would, but you know, I'm still telling my clients to file representation petitions. You know, my concern about CEMEX and waiting for an employer to file an RM petition or waiting for a bargaining order from the board is that just takes time. And if you have the card support and you have, you know, the resources, just file the RC petition. And, you know, you lose a lot of control when you're waiting for an employer to, you know, file an RM petition. And there's going to be all kinds of employers gaming that, and, you know, slightly changing the unit description from what you demanded a bargain, where there's going to be all kinds of delay tactics in that, you know, in that procedure that employers are going to use. But if you file the RC petition yourself, you sort of take back that control. So, I mean, time will tell. Maybe I'm completely wrong about that, and everyone should wait 2 weeks for them to file an RM petition, or for you to get a complaint and, you know, from the board on an 8A5 charge. But I don't know. My recommendation is to still file the RC petition, but take that with a grain of salt.
Okay. Maybe our next set of panelists can also weigh in on that question too. What's more a strategy question. So, and also Nolan made reference that the NLRB's hearing officer guide is a helpful resource as well.
Yeah, absolutely.
Yeah. So, that's wonderful. Thank you, Ben. That was very thorough. And by the way, the PowerPoints will be made available with the recording on our website. So they will, and you can find that, and the website is in the chat on the top, the Center for Labor and Community Studies. All right.
Thanks, Michelle, and thanks, Ben. We're going to move to the second half of the panel discussion here, which will include Jordan Easley, who is the current organizing director for the International Chemical Workers Union, and Brian Shepard, who is the UAW organizing director.
Thanks, Nolan. In regards to just union organizing in general, right, it requires careful planning and communication. We foster open dialogue amongst employees to understand their concerns, and education is very important when it comes to organizing the benefits of unionization and address any fears or doubts. We build and support the community within the workplace. Collaborate with experienced union organizers, fellow legal guidelines. That's where we rely on the NLRB and our legal team, so that we can tailor our approach to specific needs in the culture of the workplace. So effective communication is definitely important. Transparency is definitely key throughout the process as well. I'm not sure if everyone has noticed, but there's been an upswing, right, in regards to the labor movement, especially organizing as well. It hasn't really been as popular since the 60s, really, the mid 60s. And worker to worker conversations are very popular today. And for people like Brian and myself, that's really the inoculation piece of our own goal, right? To see that people see the vision and use their voice, because that's what they deserve in that regard. So nowadays, more Americans support doing more for workers than almost any other comparable political issue that you can think of, right? So there is a moment right now, and I think it's a meeting of different things going on at the same time. Part of that, I would say, that's just my opinion, is the aftermath of the pandemic, right? The sense that the frontline workers really took the brunt of the pandemic and kept the economy going, essentially. So what we do as organizers is make sure we rally behind these workers so they can be the best version of themselves. And that's truly important, right? We can't move without them. I say all the time, the first three letters of the union, you and I, right? So I think that's culturally more acceptable to do that now, to use your voice and put that to action. And that's what it takes to be organizers, to, hey, we can talk all day about these issues, but what are you going to do about it? In regards to the chemical workers, essentially, right? We deal a lot with the Armor Globe, right? The Armor Globe election permits employees sharing a community of interests with the already represented unit of employees to vote whether to join that unit. So to organizer, that seems like a dream, essentially, right? Because you already have a unit that is unionized and everything of that nature, but it's actually not as easy as people think it is, because of the fact that it takes time. You have to do it at the right time and make sure that you have that support from the other units as well, who are unionized as well. So it is important that we do things in a strategic way, and we rely on our legal team to make sure we have the logistics when it comes to that. Also, to tie into the NLRB, the joint employer decision has been delayed until February 26th, I believe, and you guys can correct me if I'm wrong on that. But I believe it's February 26th. So essentially, if you do have any campaigns and you are filing and you are going public and everything, that's something that you can negotiate. So that way contractors won't be, they won't have that 5 to 10 year program, essentially. Right. And if I'm not mistaken, Brian, I think you guys did something with UAW in regards to shortening the time of being TPTs. I'm not sure the logistics of that. So I'm going to swing it to Brian, and I'll piggyback off him.
Sure. Thank you. Just on my intro, I just wanted to say I'm originally from the Philadelphia area. Nolan, I think that intro was of a alt-right hit website that they created to paint us as a bunch of radicals when we were organizing in Iowa. So I'm originally from the Philadelphia area. And then I want to say to my organizing friends, before I jump into it, that I honestly believe that a strong representative group of worker leaders is by far the largest factor in a successful organizing campaign. And then I'm going to kind of contradict that in a second. That's why I wanted to lead with that. So something we've been thinking about, and I think all of the panelists have mentioned in light of the rule changes, is we've been thinking a lot about statistics. A lot of people have talked about how there's been an upsurge in union organizing. There's been a revived labor movement. But, we think a lot about this statistic that comes out of Rutgers University, that in 2022, there was 1,249 NLRB union elections. And if folks, follow that kind of stuff, that there's 76% of those have been wins. So very high win rate. But the challenge for us is to think about, well, let's look at how that data played out 40 years ago. So let's look at 1971, when the union win rate through the NLRB in the private sector was only 50%, but there were 7,606 union recognition elections, right? And so the win rate has gone up, but the amount of risk and the amount of organizing taking place has actually gone down. And for our union, especially when we look at pre-NLRB, when we look at the 30s when there were strikes for recognition, you know, in the 30s, they were losing basically 7 out of 10 strikes for recognition back in the 30s when the UAW was being built. And so we think with these rule changes, and in particular, going back to a shorter election period, the 20 to 25-day period that was talked about earlier, that maybe there is an opportunity. And so the conversation we've been having is we acknowledge that the employer just has an overwhelming amount of power in the workplace, even with some of these positive decisions coming through. And so most of us utilize what's called a structure-based organizing model, which is utilizing, you know, the no shortcuts, deeply methodical, often incremental approach, where staff organizers are building committee and we build out from there. What we've been looking at is, are we in a moment where we can utilize a momentum organizing model where we're going very public, very early, polarizing both workers and the public in order to get them to choose a side and take them from the sidelines and get into action. So for us, as we launch,
Excuse me a second. There's somebody who's unmuted here. Scott Bunch, can you mute your mic, please? Otherwise, Michelle, can you mute him for us? Thank you. Go ahead, Brian.
So as we launched campaigns on all the non-union auto assembly plants in the country just a couple of weeks ago, we've taken a different approach where we're being very public and utilizing the use of unfair labor practice charges we filed against Honda, Hyundai, and Volkswagen. And in some cases, we've seen just that act where companies were planning on doing captive audience meetings, they kind of backed off of that. So they're doing more subtle forms of union busting, but they actually backed off of it because we did it very quick, right? The first instance of a UOP, we filed and we put that out to the public. And B, we talked about it on a Facebook Live. We went through and highlighted the workers that were going through these challenges. And so in the Honda case, you know, we saw workers getting told that they had to remove stickers from their hats, workers pushing back on their employers saying, no, if people can wear other stickers, we can do it too. And then management backing down. So I don't know that that's going to continue throughout, but it's definitely a different approach. And we think with the pre-2020 election rules happening at the end of this year, we all know that the longer the employer has the campaign, the more they can divide the workforce, the more they can spread the anti-worker and anti-union message. And so we think there's an opportunity to really push this year to organize and kind of go in a way bigger scale. We haven't really looked at the CEMEX decision as it's been talked about. It sounds really awesome. I think one of the things that both we've heard from legal counsel at both the AFL-CIO and our internal legal counsel is, you know, it could end up in a situation where you're ended up in litigation and challenges. And as we all know, workers really don't have 1 year, 2 years to wait around to form a union. And so we're really looking to utilize the quicker elections as a way for workers to build power across the entire industry. And so that's kind of what we're doing. And I can go into details about what our overall plan is, but that's what we're most excited about with the rule changes. And again, I think no matter what the rule changes are, the employer the deck is stacked where they just have an overwhelming amount of power over their workforce. And, you know, so we're really putting it in the hands of workers and build worker committees everywhere.
Brian, I actually think that we would love to hear sort of an overview of UAW's organizing plan coming up over the next year. I think it's really interesting that kind of a shift in approach with this momentum model. I'm curious about like how UAW decided to take this approach and how you're changing your internal practices in order to try to engage in this moment.
Yeah, that's a really great question. Now, to a rookie organizer, again, I know there's a wide range of folks here. To a rookie organizer, I would not advise the practice we're doing, and I say it with that caveat. The UAW has had a long history. I've only been with them just over 8 months. A long history of kind of bargaining not in public, and so with the leadership change that happened in late March, what we saw was an open and transparent process where we involve members in negotiations, taking direct action, and workers mobilizing. A lot of people focus on the September strike deadline, but that work started back in June, where we went through and educated locals all across the country on what the priorities were, how they could talk to their coworkers, and what the plan to win was. And so members were involved in that process, which to me in my past experience was a common practice, but for the UAW was a new thing. And so we saw tens of thousands of people engaged in bargaining when typically it had just been like the bargaining committees, the national bargaining negotiations dealing with the companies. And so because we ran that in such a public fashion, and because auto workers have a common identity, what we saw was thousands of auto workers across the country reaching out to us and saying like, hey, they did that at GM, we want to do that too. Hey, I work at Toyota, this is what our starting rate is, here's where we top out. It hadn't been that way. Part of this is like the public nature of the campaign we ran, but also the contract that we won, where it used to be that the non-union companies, which a lot of folks don't know this, outside of GM, Ford, and Stellantis, which used to be Chrysler, there are no unionized auto assembly plants in the country. A lot of people don't realize that. And so the non-union companies have been able to create a kind of a similar wage scale, and in some cases better wage scale than you saw in union contracts. And this last contract just threw that on its head. And so we've really utilized the momentum of that into talking to auto workers and helping people develop a common identity as auto workers. And then we're doing what's called the 30-50-70 plan. And what that means, and again, this is where I would not recommend this to rookie organizers. What that means is we're really putting it in the hands of workers. And so we're dropping cards like right from the beginning, where you put cards in the hands of workers and they're signing up their coworkers, and then we're teaching them and building leaders as we're kind of making the road by walking. At 30% is where we're officially going public. And so going public means the committee is public and out there. We're being very bold from the beginning. We're doing videos and kind of talking about the issues. At 50%, when they get to 50% of their coworkers signing cards, we're organizing a big public rally with our UAW leadership, with the committee, with their neighbors, with the community, to really put the pressure on the company to show that workers are fighting for what they deserve. And then at 70%, that's when, once we have a committee made up of workers from every shift and every job classification, we demand that the company recognize the union. Think about that as like a march on the boss, not necessarily utilizing the decision we talked about. And if they don't, then we file and we take it to a vote. That's kind of our model, which is a big departure from the structure-based model that I was taught for the past 23 years.
Awesome. We have a question in the chat that was just posted by Riley. This was directed to Brian. The UAW has been focusing on the non-unionized plants in their organizing efforts. What would your advice be for someone who is looking to organize at a location that is not included in those locations? someplace where there is a distinct interest in organizing, but practically no prior experience. What would you recommend for those organizers to get support for their organizing efforts?
Well, I mean, if it's not a part of the UAW's like jurisdiction, I would say that it would be seeking out whatever local unions are in the area and figuring out which local unions can give you the support to do so. I also think the Emergency Workplace Organizing Committee, or EWOC, is a really great resource for workers that are looking to organize. It has a lot of tutorials, a lot of resources for people to use.
Awesome. Okay. So I was going to suggest that, Jordan, I know you've been working on smaller, I think smaller employers. And did you want to talk at all about, maybe some of the organizing you've done in the past and the approaches that you've used and what seemed to work and what didn't?
Sure. I think the education piece is always important when it comes to organizing, and whether it's a small unit or a big unit, it's important to be clear and concise in your messaging. So that way it will send a ripple effect to the potential membership and to these people, to the workers and everything. I would say that in regards to, your rights during organizing, I think that's very important. And even if you're a new organizer, or you're an organizer who's been there for a while, right? They can't, managers, supervisors can't spy on you or make it appear they're doing so. They, coarsely question you, threaten you, or bribe you, or things of that nature, right? And I say that because oftentimes when it comes to organizing, a lot of these workers are nervous and scared of retaliation. Right. That doesn't matter if it's a small unit or a bigger unit, right? That's just what it is. Sometimes more than likely they're breadwinners of their families, and they're not trying to ruffle any feathers that some might already be doing already. So working time is for work, right? Your employer may maintain and enforce non-discriminatory rules limiting solicitation and distribution. Right. So these are things that I would say I harp on fondly because of the nature of what we're doing. And there are multiple phases of organizing and winning an election, and especially when it comes to the first phase, I definitely like enlighten the fact that you have to talk to people you can trust the most at first. If you don't do that, you just never know, right? The employer might throw a few extra dollars in your face and dangle something that might happen 5 years ago. It's the most craziest things that will happen if you do get exposed in regards to having those conversations with workers and stuff. So obviously that doesn't happen throughout the entire phases of organizing, but the first phase and fielding leads and stuff, it's all about putting skin in the game and seeing how we can talk to more workers. Because if you are an organizer and just in general, we want to make sure that we don't burn you out. Right. And by not burning you out, we challenge workers to, bring a list, bring a schedule, provide a name, someone we can talk to. So that way it's all, everything doesn't fall on that worker himself or herself. So when it comes to just organizing in general, I think educating the membership, the potential membership, about what they can be up against, how to start a union, the do's and don'ts. Those things are very important, because at the end of the day, you don't want that to be a blowback on you, essentially, and say, hey, you didn't tell me these things, or whatever the case may be, because that will send a ripple effect in a negative way. So we just want to make sure that we are open and honest when it comes to organizing, even if it's something the workers don't want to hear. You all, at the end of the day, have their respect, because at least you're open and honest in regards to what they're up against. And when it comes to like authorization cards, those expire within the year. And oftentimes, it's about re-engaging membership, potential membership. Sometimes it's a hot shop, right, at that moment. And it might not be hot for a long period of time, but at the same time, we don't abandon leads, right? We might put them on ice, but we don't abandon anybody. We just have to make sure that the workers understand that it's up to them to see the rights that they deserve and to use their voice in the best interest of their coworkers.
Okay, thank you, Jordan. And Nolan put in a question into the chat, which is a good question. My question for both, as Brian pointed out, the number of organizing campaigns now is significantly less than 50 years ago. How should unions scale up organizing while operating with limited resources?
Yeah, there is to staff our way to that, in my opinion. There's no way to staff our way into doing the amount of scale and honestly the demand that workers have to organize right now. So I think we have to be a little bit more bold about putting it in the hands of workers and teaching them how to organize, which I know goes against at least what I was taught, a lot of conventional wisdom that things had to be staff developed worker leaders, and through this process, I think the only way to get to scale is we need to be able to train more rank and file people, both our existing membership and people who are non-union workers, how to organize. We just have to teach more people how to organize. And again, I think as the numbers played out, I don't think we can be afraid to lose.
I had a bit of a follow-up to that. So the UAW has, in their last constitutional convention, included organizing committees as a standing committee in all the locals. And I wanted to know how to speak to that. Is that something that would be it seems like that's what you're saying, that's the existing members would be involved. And what's the expectations of those organizing committees?
That was recently put into the UAW Constitution. Some regions have very advanced existing organizing committees already. A good example of that in Michigan is Region 1A. They have a totally member-led committee that spends a lot of time training members on how to follow up with leads, how to go engage suppliers to the big three automakers, how to really find organizing targets, and they just they will consistently probe and take workers to election, usually on a smaller scale, anywhere from 20 to 3 to 400. But yeah, that's something we're working on developing in all the regions, is that kind of organizing muscle in all of the locals where, that's a totally member and volunteer-based program.
Very good. Jordan, did you want to speak to that at all? To what unions can do to increase the organizing?
Yeah, to Brian's point, I would say that it obviously it'd be nice to have more organizers. But at the same time, we just have to do a better job of educating the workers and stuff and create an organizing dialogue with them, right? Maybe they're not an actual organizer, but it's up to them to be organizers in their workshops. So part of that, like I said earlier, it's just having that open dialogue and being honest, especially when there are tough times, and just be a beacon of sending that ripple effect amongst that leadership to the workers. Organizing is a shortage of organizers these days. Obviously, we had a lot of organizers that would definitely outweigh this mission in terms of making sure workers are educated. When it comes to the larger units and everything of that nature, it's definitely important to create, team leaders or depending on the size and stuff, maybe take that in terms of the, numerical value of how many leaders should be in your unit and stuff, and strive for that. At the very least, they could be relaying the message that you're trying to portray. So I would just, like I said, to Brian's point, it's really just creating more leaders in these units, in these workshops. I think that is probably the most constructive way to, align when it comes to not only the winning percentage, but how many elections there are as well.
Thank you. And I had another question, if I only show my face. It's to you, Brian. I know you and maybe in Jordan as well, but I know that you worked with SEIU for a number of years. I'm just wondering about the different tactics or the strategies that were used, and how just what was successful when you were representing more service, I'm assuming service industry folks, as opposed to industrial workers. Just what were some lessons that you learned from SEIU that can transfer or can't transfer? Just any other lessons that you had from other experiences besides UAW?
I think one of the most common myths we try to dispel is that this notion of like, we're different here. I think a lot of us who have been organizers hear that. It's like, well, nurses are different than janitors, or public sector workers are different than industrial workers, or it's different here in Texas than it is in Pennsylvania. And so, I think there are universal principles of organizing that cut across industry and sectors. And of course, there's different cultural competencies or regional issues to take into account, or, in some cases, state governments and legislation. But for the most part, I think, it is, I think workers have been getting screwed for my entire lifetime, the past 40 plus years, and I think I honestly believe we're at a breaking point. I think we're at that tipping point where people are totally fed up. And so I don't think there is there's definitely some differences in approaches, and definitely with the UAW we are doing a far more worker-driven, worker-led movement than focusing on staff. A lot of people were shocked at how, I'm not going to say the number, but how few staff we had working on the contract campaign. Some people are like, oh, you must have had 200 people. No, it was nowhere near that. It was more like a dozen or so. And it really was just getting out of the way of the workers and the locals, and providing them with support and training folks.
Very good. Yeah, and just I had represented faculty at Wayne State, and including people with MDs and PhDs, and people would say, oh, it must be so different. And to your point, I would say, well, they might have a larger vocabulary, but the issues are still the same. They're being screwed over, it's issues of dignity. Issues.
That's the root of organizing, right? The boss has power over everything in your work life, and workers do not. And people have to make a decision if they want to organize and do something about it, to take power.
Correct. Okay. Looking to see if there's some more questions. Jerome, for the newly formed local organizing committees in regions that are not as strong or advanced in organizing efforts or training, as this icon's in my way, as is it out of protocol to reach out to other regions for support and training? So I guess this is a UAW.
Very UAW question. Yeah.
A very UAW question.
Yeah, and I don't want to. But the quick answer, Jerome, is we have been talking with regional directors. We formed a group of regional directors that are helping to advise on this national organizing campaign. So 4 of the regions meet with us on a weekly basis so we could talk about progress and strategy and feedback. One of the needs we've identified is putting together a national program that would help train all of the regions. And so, yes, sharing those resources. That's a work in progress, but that's exactly where we need to get to.
Very good. Let's see. Love. Let's see. More. Someone's mentioning the union stickers. I don't think that's a. Love the union stickers on hats at Honda and collectively refusing management's unlawful directive to remove them. What other effective collective actions have workers been using during the recent organizing drives?
Yeah.
Yeah. Could you?
Yeah, I mean, I just have so much respect for these non-union auto workers who are just standing up to their bosses in ways that they just haven't before. Neil, I think the other big thing that people have been standing their ground on is leafleting. You know, a lot of folks have been told they can't pass out leaflets at the gates. That's one of the effective ways auto workers are able to talk to one another. You know, pushing back on if I get, again, it's all the classics. If I can talk about the Girl Scouts or I can talk about the football game, well, then I can talk about the union during work hours. And so we've seen that happening. What we've really tried to do is have both on the ground organizing committees, but also we've been holding national Zooms with folks to have a national organizing committee. And so we've been training them on the acronym SPIT, like people really like this, like don't let the employer spit in your face. And that's surveillance, promises, intimidation, and threats. And so we've really been training people on that and how to look for when the boss is breaking the law. And I think that helps people. It's like, this is when your boss is breaking the law, and that helps make people more bold, right? We just come out and say that, that if they do any of these things, they're the ones breaking the law. They're the ones that are in the wrong.
Jordan, do you have any collective campaigns or collective actions that organizing that you've used or that the workers have used?
Yeah, absolutely. I think just to the point, even just to the stickers, right? You want to show, you want to escalate leadership, right? You do build leaders throughout the process, and we call that public support, right? Where you are open to wearing stickers, vests, T-shirts, whatever the case may be, you know, to show solidarity amongst your coworkers. And you know, usually that's a smaller number, or if you know, in the perfect world, everyone in the unit will have you know, that said public open support, right? But that is part of the whole education narrative too, right? We are explaining how the process goes, and we are we're side by side when it comes to the steps of forming a union as well. So, I mean, the open support, I mean, that's one of my favorite parts of organizing, because, you know, you're not just taking a sticker. What does it mean to take a sticker? What does it mean to take this, you know, this paraphernalia essentially? So, again, I think open support and public support is a beautiful thing, right? That's, you know, that is part of what we're trying to, you know, coach and show the workers why it's important to use their voice. And that's just multiple ways to use your voice when it comes to that open support and that public support.
Okay, very good. I have some questions in the chat here too. And also, if there's any activities that any of the organizers here wanted to share, you can let me know in the chat too. That would be great. One of my favorite one was when workers they made these cardboard things that went over their ears, and when they were called into meetings, they would put them on. They called them bullshit protectors when they were to captive audience meetings, and they all had these red things on their ears. I think making people laugh too is a way to overcome fear. Let's see, has there been any noticeable, so Nolan, has there been any noticeable differences in how different non-union auto workers are responding to organizing campaigns? The worst of the worst? Did I convey your question correctly, Nolan?
It actually was how the manufacturers are responding. Like is Honda different than Hyundai? Like just how are the different ones reacting? Because you kind of announced like we're going to organize like everywhere. So I didn't know if there's a difference in how the manufacturers are responding.
Yeah, so again, we're only a couple weeks into the process, and I think folks heard last week Volkswagen already hit that 30% benchmark, and we're going to have another update maybe next week. I don't want to spoil anything, but I mean, we're moving with enormous speed, where I think that has caught for the first time in a long time. That has caught the employer off guard. We're also heading into the holidays, and in auto assembly, the plant's shut down. They have a shutdown period. So we're definitely in a, we're kind of, the worst of the worst. I don't know if they've started all the way yet. I mean, Hyundai has been running captive audience meetings on a regular basis. Again, I think the difference is because we ran such a public campaign during the contract campaign, when they're doing these meetings, and Hyundai like matched like basically the wage increase, workers called that hush money. So like workers got it. A good example is also Toyota. Toyota in Georgetown, Kentucky. I've seen workers turn on each other for 50 cents. They gave people a $2.97 an hour raise, $2.97. That same week, over 700 people signed a union card, and then close to 100 people showed up at a union meeting that week. I've never seen that in 23 years. We're like, workers saw right through it, and we're like, yes, and we want more. That's what organizers try to get to and claim a victory, or what we call the UAW bump. But we didn't have to even create that. Workers really saw through it. Again, that's where I think our campaign is a little different, that I wouldn't advise, because you can't really separate it out from the contract campaign and how that went down.
Right. So Tamar wrote, love to hear more from Brian about how these principles are being implemented for internal organizing, not just new organizing. How do you keep established union members organized? My local has been around for 20 years and has been dormant much of the time. How do you suggest bringing militancy into long established locals?
Yeah, I mean, I think the contract campaign was the first time that the organizing department had a role to play in contract negotiations. That was a big shift for the United Auto Workers. We saw tens of thousands of people get mobilized and militant throughout that process. It got to a point where we had originally planned 12 major actions the week of the strike vote, and then it just kind of got out of hand, where then there was over 121 actions happening because people just didn't want to get left out. I would think that's a conversation definitely that needs to happen at the local and regional level. That's the kind of internal side is I think that's going to happen at the local and the regional level.
Okay. And I see Jesus also put in a response down here. He says, my own 2 cents, this last question is the wrong question to even consider. Organizing a dormant local requires people to be uncomfortable with what members, leaders, organizers are hearing from one-on-one conversation. If a local is dormant, it is going to be a major jolt when talks about militancy mindset enters the conversation. So I don't know, Jesus, if you wanted to say anything more. start with a one-on-one with all workers, find their key issues to be addressed now or in the next bargaining cycle. So this is advice from Jesus. So. All right.
And I see Jesse Kelly had a question too. If I could.
Okay, thank you. I appreciate all
Because I
that.
have a strong opinion on that one. So
Oh,
Jesse
okay,
Kelly said,
okay.
Brian, do you believe that sharing the number of percentages of members who have already signed up during an organizing campaign helps get other workers to join in? Or do you believe this just ticks the pushback by management? This was a big cultural shock that I walked into at the UAW, and a conversation I had with workers in Alabama was there had been a practice that you never share the numbers of like where a campaign is at with the organizing committee, let alone like the workers. That is completely foreign to me. I think the way to do it is you've got to be transparent, because people need to know like where they're at in the process. That's why we've been very adamant about the 30, 50, 70. And what I said to these workers in Alabama was like, not only am I going to share the number with you of where you're at, I'm going to share the spreadsheet with you in real time so you can follow up with your coworkers who signed, and you can recruit them to the organizing committee. So it's like not only am I going to share it with you, that's going to mean you have to do more work.
Yes, thank you. And I see, thank you for that. I don't know, did anyone want to, Jordan, did you want to have anything more to add or no?
No, I think Brian pretty much captured
Okay.
that question for sure.
Yeah, sorry if it got a little too UAW specific there.
That's
No
okay.
worries.
Let's see. Oh, there's a question that will this be recording be made available? I'd love to pass it on. Yes, and I keep reading this, but when people ask, I lose. Obviously, I'm having. I lose the thread because when people add on, it goes away. But anyway, yes, it's going to be recorded. It's going to be on our website. The website is the first entry onto the chat. And it's the Center for Labor and Community Studies at UMD. But you should see it up there. So we're going to have it on our website along with the PowerPoints. And you can also see about the organizing network meeting on January 13th and the Black Men in Unions. We have a Black Men in Unions conference coming up in February as well that you can register for. So all of that is on our website, including the link to the recording. It will be as soon as we get it. Okay. Brian,
There was a couple of questions I had seen earlier. One of them is advice about conducting organizing campaigns with remote workers.
Oh, yeah.
I know that was something that came up obviously a lot during the pandemic. And just looking for best practices or advice from the organizers here about remote work organizing.
I would say it's easier said than done. But at the same time, organizing is about meeting people where they're at. So, you know, I know when it comes to nursing during the pandemic, they were mandated if they answered the phone. So I'm not sure in regards to the question, are they generally remote workers, but it's all about meeting people where they're at, and what we did when I was with the nurses union, we were flyering, we were at the bus stops and things of that nature, given that we didn't have no access to the facility like we usually do. So I would say that, I'm not sure what the logistics are, but obviously channel the best way to meet people where they're at in that regard. And you could always have a meeting. Even if it's a weekly meeting, if they're all remote workers, then they are naturally attached to their phone or laptop or some type of technology. So that was something that I would use that to my advantage in terms of reaching out to them and figuring out how we can get as many people on this meeting as possible.
Okay, I have another question unless Brian wanted to weigh in.
No, I was just going to say that was exactly right. And I remember organizing librarians in San Diego County in 2001. And even though they were spread out among a massive county all over the place, they were on something called the internet in 2001. For those of you that don't remember, like was not like a daily practice. And they could just disseminate information faster than any other part of the county. They could communicate with one another. And so sometimes it means giving up our conventional practices of thinking we got to get everybody in person to get to that kind of that scale.
Very good. Okay, Roland Zulu has a question. Can you comment on the role of captive audience meetings? How do you counter them? How effective are they? What would change if they become an unfair practice? And I thought I heard that they had become an unfair labor practice, but anyway, Elizabeth, is it an unfair labor practice to have captive?
Yeah, the general counsel is pushing us to get that before the board, so the board can decide if it's going to be unlawful.
Okay.
And so what you'll see is, many regions are prosecuting captive audience meetings. So if you bring it to us and there's a violation under existing law, that is something we would litigate, but we're waiting for the board to pick it up and say yes or no.
Yeah, okay, thanks for the clarification. It sounds like Roland got the message better than I did. But anyway, how to counter captive audience meetings. Anybody want to respond to that?
Well, yeah, I would say that, that's a fear tactic essentially, right? That clearly that sheds light on how the employer is scared in regards to when you guys come together, like, not you all, but when it comes to the workers that come together and use their voice, right? Small group employee experience meetings is what usually how it will be worded when it comes to us. And that is just literally saying, hey, talk to us before you talk to the union. If you have any questions or concerns, you can come to us. I would say oftentimes that those emails or conversations at the lunch table stuff, usually that happens when workers are fed up. Brian, I don't know if you want to allude to that, but workers are usually fed up and they're talking and the whispers are there in terms of possibly having a union. And that is a soft way of saying, hey, we're gonna shut everything down, but first come talk to us, right? We're here for you. We have a pizza party for you, right? Things of that nature. So we use that as fuel, right? Why all of a sudden they care about the issues that you have going on, right? That means that they are they're scared in terms of you guys are coming together, right? A movement by yourself forcibly together, essentially. So I always love those. I always love getting sent those emails and everything. Screenshot those emails and everything from workers because that means we are escalating when it comes to forming a union for sure.
So I think I'll go right back to what I said at the top, which is that a strong representative group of worker leaders is by far the largest factor in a successful campaign because the captive audience relies on a lot of different factors, but at the root of the captive audience is that the union is somehow a third party, that they're an outside entity. And so if workers are the ones driving the campaign and workers are the ones organizing their coworkers, the captive audience isn't as effective because there is no outside influence. They literally understand that it's them forming a union. And so workers understanding that and communicating that to one another is the best inoculation against the captive.
Thank you. See, Nikki has a question. Do you have any advice? Oh, this was the remote working one. Sorry. Do you have any sense of the list or total amount of the workforce? Oh, no, this is sorry. I am the worst question reader. I'm so sorry, everyone. I'm getting there. All right. You've answered all these questions.
There's a question there from Joni. How can we get the boss's campaign strategies more public for places and people to see, for the places that are being organized right now so they're prepared, but not just from their particular organizers? And if I could actually piggyback on that question or add an addendum, I'm curious about the inoculation approach in very large scale campaigns. Brian and Jordan, if you attempt to get a supermajority of workers to go through a full inoculation session, or if that's not practical in campaigns these large.
No, I would say it's practical. It's just more of the timing of when you want to relay that message, right? Because when you are having these conversations and stuff, you don't want to overload these workers' circuit. You don't want to bombard them with all this information. So I would say it wouldn't happen during the first phase when it comes to my experience. But as the campaign escalates, absolutely. I mean, that is, the company messaging is obviously a pivotal part of when it comes to organizing. But I found that throughout the years, if and some people can retain all the information right then and there, but more than likely they won't, or it's just it becomes more forgettable. So you have to, as organizers, really pick apart when you want to use that as part of your one-on-one conversations, and you can have one-on-one conversations throughout the whole campaign, right? So I would say it's timing. That's the biggest factor when it comes to using that chip, essentially, because what you talk about on day one might not be different. I mean, might be different when you talk about day 7 or day 16 or day 25, where the case may be. But absolutely, I think it's important to use that as part of your messaging, but the timing plays a definite role in that, from my experience.
We have another question. Can we get suggestions on how retirees can help their union? Any ideas?
Well, I'm not sure who asked that question and which union you're part of. I would say that just in general, just a general answer. Retirees are just as pivotal as people who are working as well, right? They can relate. They've been through the struggle. They understand. They understand the lows of the organization, the lows of the company, the highs of the company. They've seen a lot. For them to retire, right? More than likely, they've been there for a long period of time. I would say you still organize the retirees too. I mean, it's an organizing fest, right? Your workers need you. They're still your workers. They're still your colleagues, even though that you're retired. I will organize them just the same, right? Sometimes it does take a retiree to relate to those workers. Obviously, workers know what other workers are going through, but and retirees obviously know what it takes. So for organizers who might not know the ins and outs of their workshop yet, you bring a retiree in, especially one who's been respected throughout the years. That plays a very major role when it comes to your organizing efforts.
Any thoughts, Brian?
Yeah, I mean, most unions have some program for retirees to be able to share their experience, as Jordan said. I think on the extreme end, there's a woman, her name is Lori. She was a retired UAW member. And then she went to work at a non-union assembly plant. So she's 60 years old and she's working on the assembly line. And she's doing that with the explicit purpose of like, I've got a year of work left in me. I'm going to go organize this non-union facility. So I think that's the most extreme end of it. I think, getting to your local union hall, finding out what, ways to help there is important. And then Lori's example is like, she's like, I'm going to do this before I'm done.
That's wonderful. That's great. And Nolan, do you see any more questions that I missed?
I don't. I think that we've got all of them read at this point. There's just a new one was put into the chat. However, I am part of a small nonprofit union that is in the middle of contract negotiations. The employer is telling the negotiating committee that they are not allowed to tell the members of the union anything that has been agreed upon in the negotiations, stating that all negotiations are confidential until it goes to the membership for vote. Is this true?
Brian or
I think
Ben?
on that one, I need some more specific details. I don't know what ground rules were agreed to. I don't know what the local situation is. Every local has different ways of doing that. So I just need more information. So if you could email me.
Right. I am.
I would just based off what the posters said here, assuming there aren't ground rules, I would say no. I mean, I don't personally, I think ground rules and bargaining are sort of fading away. And then I think confidentiality in ground rules is even like, that's like a dinosaur's dinosaur. Like, I rarely see that. And I think, with the general counsel's position on confidentiality, like banning discussions about bargaining, is, extremely antithetical to the act. So, I mean, it's possible there are some ground rules here. But I mean, I would be surprised. And I'm not sure that how enforceable those ground rules would be. I mean, I think it's problematic for sure.
Thank you. And let's see.
I think we have time for one more question.
There's a question in the chat here. I would like to know how Ms. Kerwin feels about workers using recording devices at captive audience meetings. And I guess Ben, you could also, or anybody.
Yeah. Our view and we're a neutral, right? So except when we put our hat on to prosecute a case. So what I'm going to tell you is probably really different than what Ben would tell you. We kind of just deal with the evidence we're brought, right? And so sometimes what we're brought is a witness who's going to sit down and tell us the whole story. And we're going to write every word they say. And they're going to say, here's what was said at the meeting. And that's going to be a sworn affidavit that we're going to take into court and prosecute with. Sometimes the witness brings us the recording. And then there's absolutely no question about what was said. It's not a credibility issue anymore. We don't have to go knock on 30 people's doors who were also at the meeting to see what they remember was said. We have the recording. So from the standpoint of, investigating and prosecuting a case, a recording is a wonderful thing for us to have. There can be some real pitfalls with it. If you're recording and your employer has a no recording rule, first of all, we are prosecuting no recording rules. That's a big one, but that can be so tricky. If you work in an auto plant and you work in an area where there's really high trade secret, high confidentiality things going on, and you're taking pictures of that stuff or you're recording, I can't promise you that you're not getting in trouble for that. That's also not for me to look out for. That's for Ben and others to look out for you and give you legal advice about what you should or shouldn't do. Just from the NLRB's perspective, when you walk in with a recording, it sure is helpful for us. But we don't give advice to people about what they should or shouldn't do. And I see Riley's question in the chat about, is Michigan a 2 consent state? I believe it's a 1 consent state.
Yeah, it's
I'm
1
going to let Ben tell you what you should do, because I can't tell you that.
So in Michigan, if you're a party to a conversation, and I want to emphasize that if you're a party to a conversation, you can record that conversation. And I think there are certainly states that are 2-party consent. And I practice in Michigan pretty much exclusively. I don't know. I'm not sure how that is, a 2-party consent, how is that impacted when you're doing a captive audience with 50 people? I just don't know. But in Michigan, record away. I mean, I agree from an evidentiary perspective. When I have 4 people who sat in a captive audience meeting and they tell me all the different things that they heard, no one tells the same story, even if there are slight variations. And for an ALJ to sift through that, it can be, difficult, and it obviously creates credibility issues. And an employer is going to say, well, employee A testified that they talked about green buses. Employee A said they talked about, orange buses, and they're telling different stories. It's not credible. But if you have that recording, then the credibility issues are essentially nulled out.
Well, we're at time for this event. I want to say thank you to the panelists for taking the time on this weekend day. A lot of great information, and thank you for all the attendees. A lot of really great questions. I thought that this was a really excellent discussion about such an important topic. So thank you, everyone, and have a great weekend.
Thank you. See you.
Thanks, everybody.
Yeah, thank you all. Appreciate it. I have a question for you, Nolan, before when everyone goes.
Sure.
Is there gonna be an after discussion?
Only if you can tell me how to record.